Okay. Okay. Good afternoon, everyone. Welcome back. Just realized I written 1 p.m. over here because 1 p.m. was when we broke. It's 2 p.m. I'm sorry for that. Okay. So we were dealing with the RTI Act. In Section 5, we were taking a look at the formation of the PIO. Right. So what we're taking a look at is how a public information officer is at the head of a organization who has access to all the information on the organization. Right. I gave you the example. If you have a university, chances are the vice chancellor is the public information officer. Okay. Who's the head of the organization, and he is also the one who's in access to all the information about the organization. Right. So since he has access to all the information, he is the best person to be able to give access to information to the common people. So every person, single person who's looking for that department can go to the PIO / vice chancellor, file an RTI application, and on the filing of the RTI application, he can get a response from it. Okay. What you asking the question? Where can we file an RTI, in a court or in that department? What have I been telling you here? So long I've been telling you. Come on now, please. पब्लिक अथॉरिटी जो डिपार्टमेंट है उसी में कर सकते हैं आप. You don't have to go to the court. What you can do is you can take the information that you have got from them and you can bring this information to the court. Okay, and then you can tell the court on the basis of in this information that some kind of a scam is happening. Information तो आपको डिपार्टमेंट से ही मिलेगी ना. कोर्ट के पास थोड़ी इंफॉर्मेशन होती है अबाउट अ डिपार्टमेंट. Department will have the information, it will give the information to you directly under the RTI Act. Yes, Spandan has written a long question here. Okay, this is about the RPA. And okay, Subrata has written about the RPA, and we have a question by Spandan. Okay, we'll take them. I'll look at all these questions. I'm enthralled to see you engaging vigorously in this discussion. Okay, now we are taking a look at section 5 we have completed about the PI. Let's take a look at section 6 of the RTI Act. Section 6 of the RTI Act. Let's take a look at this. Request for obtaining information. Now, this is basically tells you the procedure by which a person can file an RTI application. Okay. A person who desires to obtain any information under this act shall make a request in writing or through electronic means in English or Hindi or in the official language of the area in which the application is being made, accompanying such a fee as may be prescribed to the Central Public Information Officer or the State Public Information Officer or to the Assistant Public Information Officers, specifying the particulars of the information sought by him or her. Okay. Specifying the particulars of the information sought by him or her, provided that where such a request cannot be made in writing, the Central Public Information Officer or State Public Information Officer, as the case may be, shall render all reasonable assistance to the person making the request orally or to reduce the same in writing. Okay. Now, take a look at this, basically what section 6 says, very simply breaking it down. Section 6 of the RTI Act which talks about the procedure for filing an RTI. Talks about the procedure for filing an RTI. Okay, so first thing that we know is, let's say for example, if this is a person or a citizen, he can go to any public authority, locate the PIO over here, and ask for information about the public authority. Any kind of information about the public authority can be asked by a person by filing an RTI application. Okay, clear? A citizen can file an RTI application to a public authority, and on the basis of that RTI application, he can ask information, right? Who does it have to file it? To the PIO. Okay, let's assume, for example, if this person is illiterate, let's say he doesn't know how to read or write. What section 5 says is that if a person is entering into an office, let's say if a old woman goes to a government department to inquire about the compensation which was allocated to her son who was martyred fighting a war for India. Okay, so the government department has given some amount of, let's say, bravery award or something like that to um, what you call the person who was martyred as an Indian soldier, but that money has not still been given to his mother. Now his mother is non-lettered; she cannot read or write. She goes to in the concerned department, let's say, and she wants to know what happened to her son's compensation, the bravery award that has been given to her son along with the money. Okay, so now what happens is that someone told her कि माता जी RTI file कर दो जाके, you go and file an RTI में आपको पता चल जाएगा what is going to, so she doesn't know what RTI etc, she just goes into the office and says कि मुझे RTI file करनी है. Okay, now what it means is that the PIO, if he finds her, he will have to help her write the RTI application. This is not a paropkar that he is doing. It is supposed to be mandatory under the RTI Act as an obligation. He has to help the woman file an RTI, right? So it's like a bank. Mein we have this experience sometimes कि हम लोग bank में जाते हैं and we see some person who is not able to write details on their forms because they are not literate. So they say कि भैया please आप हमारा form भर दीजिए. Take a look at our form and please fill in the details from our side, and we do it, right? Now this kind of a thing has been institutionalized in the RTI Act. If a person is not able to find a way to write their own application properly in the proper format, what is to be written, where is to be written, etc, then it is a job of the public information officer or the assistant public information officer to help that person complete the application, which involves that they will themselves write the application, they will let the old woman dictate and then write the application and then make a thumb impression of her and then admit the application. You see the point? So that's basically where section 5 also appears, right? This is not something that you can do only help out of a kind of a charitable mindset. It is a statutory obligation that if a person is not able to file the application correctly, you have to help the person in filing the application. Again, I'm repeating, it is a statutory obligation, not just a kind of a charitable, a moral activity, a good deed for the day. ऐसा नहीं है. It's given in the RTI Act. Further, what is given in the RTI Act under section 6 is the fact that a person can file an RTI without giving any reasons for filing an RTI. Okay, so for your RTI application, does not necessarily have to have reasons that why do you want this information, who are you. Okay, in fact, to the point that you don't even have to give your personal details. You can hide your name or your designation or your profession, etc. You can conceal all of this. The only bare minimum information that you have to give is address where you can receive the information back. You have to just give some address. You can even give the address of your nearest post office. So you can write, for example, an RTI application can be written like this. Right? You write a set of things that this information, this information, this information, this information is what I want. What is your name? X, anonymous. Okay, and then under that you can write the address of a post office. Please deliver the response to this at this post office, from where you can collect this and that get the information, right? So RTI allows complete autonomy. Of course, the point being that if a lot of people are going to ask for information under the RTI, and if this information is uncomfortable or is revealing a major scam, etc., these people can be targeted by the vested interests. And therefore, to avoid this targeting of these people, you need a structure by which some kind of an activity uh, in which we are dealing with its core of it, right? So this is what section 5 states. Take a look at section 5, please. Where such request cannot be made in writing, the central PIO or the SPIO, as the case may be, shall render all reasonable assistance to the person making the request orally to reduce the same in writing. Okay? So you will have to, as a PIO, give the assistance to the person to file the application properly, to give it in writing. Right? Read down this. An applicant making a request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. You see the point? So it can remain completely anonymous. Doesn't have to give reasons, doesn't have to give personal details, etc. Okay? Now, take a look at this part. When an RTI application, I'm just going to move forward about this. Let's say, if let's say for example you file an RTI, with a public department, okay, and let's say the information that you are requesting X information. This department number 1 doesn't have the X information, but the PIO over here knows that this information would be available with department number 2, which is a different department altogether. Okay, so what he has to do is, okay, let's just say that you are a person who has filed for a particular information, but you filed it with the wrong department. That department does not deal with that information. It always happens sometimes. For example, you want to do with some activity, but you don't know which office to go to, which department to go to. So what you may end up doing is giving it to the wrong department as an RTI. So what section 5 says is that this PIO will have to forward this RTI to this PIO. Okay, and we'll have to get the information X from here and reply it to the citizen, either through himself or directly. You see, so you cannot, basically if you are a PIO, you cannot merely saying that this is the wrong department, don't come to us. You cannot get our information from us because we don't deal in this category of activity. You cannot just say that it is a wrong department and dismiss an RTI. You have to send the RTI to the correct department, which you know has the information, which can get the information to the person who's in need. Okay, take a look at this part, please. Please take a look at this part. Where an application is made to a public authority requesting for an information which is held by another public authority, or the subject matter of which is more closely connected with the functions of another public authority, the public authority to which such application is made shall transfer the application or such part of it as may be appropriate to that public authority and inform the applicant immediately about such transfer. Okay. And then later it says, provided that the transfer of an application pursuant to this subsection shall be made as soon as practicable, but no case later than 5 days from the receipt of the application. So for example, today if I file application, but the application has gone to the wrong department, that department doesn't deal with that activity. What you can make sure is that the information has to be given by the PIO of the wrong department to the PIO of the right department, and the PIO of the right department will send the information to you. And the movement of the application from the wrong department to the right department has to happen within 5 days. It cannot exceed more than 5 days. This is section 6 of the RTI Act. Okay, the procedure for filing the RTI. Let me just summarize it properly for you. You have, for example, in section 6, the fact that you are a citizen filing an RTI. Okay, you're a citizen who's filing an RTI, and you are filing an application to a public authority who is a PIO, and the public authority shall consider the request. The public authority will help you reduce it in writing if you cannot write it down. The public authority cannot demand your personal details or your reasons for filing the application. A minimal address upon which the response can be given is sufficient. And on top of that, if you have filed it in the wrong department, then the public authority, PIO, Public Information Officer, will have to direct it to the wrong department, to the right department within 5 days of the receipt of the application. He cannot sit upon the application himself or say that your application is rejected because we are not the concerned department that you're looking for information. The information that you're looking for is not available with us. You see the point? That's what we're taking a look at when we understand this aspect of things. All right. ठीक है? Section 6 is done. Let me take section 7 of the RTI Act. Section 7 talks about disposal. Okay, but when the RTI has been received from a citizen by a PIO, tomorrow if you become IAS officers, you will hold positions of the PIO. Therefore, you will have to know section 7. Under section 7, what you have to know is that if a citizen has demanded some information from the PIO, how is it that the PIO is supposed to respond to it? That is basically how can he and in what time can he dispose the application? What time must he dispose the application? Please take a look at this. Subject to the proviso of subsection 2 of subsection 5 or to proviso of subsection 3 of subsection 6, the CPIO or the state PIO as may be, on receipt of a request under section 6, as expeditiously as possible and in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified under section 8 and section 9. Okay, so what does it say? Section 7, it says that when a PIO has received a RTI, then he has to take two decisions. He can take two decisions. A is providing the information, and B is rejecting the application. Okay, A is providing the information and B is rejecting the application. And what we are taking a look at in this regard is the fact that both these options have to be exercised within 30 days. 30 days. You cannot exceed the period of 30 days in deciding how do you want to respond to the. Either you can do A or you can do B. Okay, get my point? That your the application over here has to be either given the information to or it has to be rejected. But it cannot be kept in abeyance, it cannot be kept in a position in which it is crossing 30 days time period. That is given under section 7. Okay. An addition to this section is that when an information which is sought for concerns the life or liberty of a person, the same shall be provided within 48 hours of the receipt of the request. Take a look at this again. Generally, an information which is asked can be provided within 30 days. But when an information concerns the life or liberty of a person, let's say for example, if a person is facing some kind of a problem with regard to his life or personal liberty, let's say if you have let's say if there's a family member of your who is caught in, let's say for example, West Asia, and in West Asia he is being told by the, let's say the authorities of Dubai that he is without visa and he is not able to find his visa. He's lost his visa. Every copy of the e-visa has been evaporated. He calls you and tells you that I may be arrested by them and I may be put to prosecution by them because they feel that I am there without a visa. What you can go is, you can go to the passport authority and ask for them under an RTI to give a reference number under which he has been issued a visa. But since it requires a question of life and personal liberty, that he may actually be arrested by the police and be prosecuted or be punished because of the harsh nature of laws in West Asia, for that reason, the passport authority will be obliged to give you the response to the RTI within 48 hours, because this is a matter which concerns life and liberty. Okay. This is a matter which concerns life and liberty. Therefore, this kind of a thing can be done clearly. Right? Are we here? Provided that where the information sought for concerns the life or liberty of a person, the same shall be provided within 48 hours of the receipt of the request. Okay? All right. So you have a time frame. For example, if you have a question as to what are the time frame within which the PIO has to respond to the request, 30 days in normal times and 48 hours if it is dealing with the life and liberty of a person. Okay, so this is all, Abhi. We don't have to read 2 and 3 about it. We can take a look at this part. Where a request has been rejected under subsection 1, the CPIO or the SPIO, as the case may be, shall communicate to the person making the request, number 1, the reasons for such rejection, number 2, the period within which an appeal against such rejection may be preferred, and number 3, the particulars of the appellate authority. Okay, so for example, if a PIO within 30 days rejects the information which has been given, which has to be given to the people, along with that rejection, he shall communicate the reasons for rejection, the period within which an appeal against such rejection can be made, and the particulars of the authority on which that appeal is going to be addressed. Okay, this is the part that we understand. So this is section 6 and section 7. Okay, let's take a revision of this from the top. Section 3 has the statutory right of the right to information. Okay, then section 4. Section 3 has a statutory right of the right to information. Section 4 has what you can call the cataloging and indexing part. Right, the information has to be kept in a particular manner. Section 5 has the provision of a PIO. Section 6 has the procedure for filing a RTI, and section 7 has the response time which is given within the RTI Act to dispose of the application, right? So 3, 4, 5, 6, 7 we have taken a look at. Just take a look at section 8 also, and we complete with this one part of RTI. Section 8, please take a look at it. Exemption from disclosure of information, right? Matlab, the question or the point that we're trying to make in section 8 is that what are the categories of information under the RTI Act which cannot be disclosed by a public authority. Okay, so what basically what you're saying is, let's say, if for example, let's say you have the government of India represented in the patent office. Patent office is an office run by the government of India, in which a person goes and registers his formula as a kind of a invention, and on this he receives a patent, right? And this allows this person to be the exclusive user of that intellectual property. So this is registered with the government. You see the point? Now, it cannot be the case that if you file an RTI saying that this is a public authority and it is a PIO, I want this patent as an information. You see the point? You can't do that because this is under exemptions. So you have to, under section 8 you have created a list of exemptions which cannot be covered under the RTI Act, and patent is an example of that. Any intellectual property which has been submitted with the government of India by a third party or even created by the government of India will not form a part of the RTI requests because it is specifically exempted. ऐसे तो आप किसी की भी पेटेंट किसी के भी फॉर्मूला को बाहर निकाल के देख सकते हो ना, उसने इतनी मेहनत करके फॉर्मूला बनाया, and you can just get an access to it without any sense of anything. So this activity needs to be controlled, and therefore the patent cannot become a part of the RTI. And exactly like this, like the patent, there are many things which have to be taken care of, which should be exempted, right? So take a look at section 8, please. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen a information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, relation with foreign state, or lead to incitement of an offense. Okay, so this is an information which is exempted. B, information which has been expressly forbidden or published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. C, information the disclosure of which would cause a breach of parliamentary privilege or the state legislature, right? This is with relation to Article 102 of the Constitution, Article 105 of the Constitution, which deals with the concept of parliamentary privileges. Right? D, information including commercial confidence, trade secrets, or intellectual property. This is the example that I was discussing. Disclosure of which would mean harm to the competitive position of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. E, information available to a person in his fiduciary relationship unless the competent authority is satisfied the larger public interest warrants the disclosure of such information. F, information received in confidence from the foreign government. And G, information the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. Okay, you see the point? So this is what we are taking an understanding of with regard to what the exemptions are. You don't have to memorize all the exemptions. It's not required for the GS paper. You can read 2-3 of them. That would be sufficient. But we're talking about section 8, which is a list of information which will not be covered under the RTI, which is basically you cannot demand as a part of the RTI. information that cannot be demanded under the RTI. This is what we are taking a look at. Okay, let's go with this again. Section 3 talks about the right to information as a statutory right. Section 4 talks about the what you can call cataloging and indexing of data so that it can become accessible for every person to read the information asked in the RTI. Section 5 talks about the public information officer, the central public information officer, the state public information officer, etc. Then section 6 talks about the procedure for filing an RTI. We've given you the understanding of the procedure to the PIO. Section 7, the response time given by the PIO, 30 days, 38 days and 30 days and 48 hours. And section 8 talks about information that cannot be demanded under the RTI, the exemptions. Okay, all of this becomes one set of information to be covered under the RTI. Okay, this forms a set. You can memorize these things very clearly. When we started the course on governance, I told you that one of the objectives of the course of governance is to make sure that you memorize certain sections which are given over here, so that you can create a set of these sections, and then by the repetition of sections only you can write your answers in a good categorical understanding of things, right? Okay, let me take a few questions that you've been writing, Obi. Okay, I'll try to answer your question as succinct, but as precisely as possible, looking at the sections of the RTI Act only. Most of the questions that you're asking can be clarified directly by reading the RTI Act. So one of the thematic questions that I can get, two of you have asked the question. Number one is, um, filing an RTI means only writing letter to PIO or writing email as well, Nimai. Okay, let's take a look at section 6 of the RTI Act. A person, section 6, remember, is the procedure for filing the RTI. A person who desires to obtain any information under this act shall make a request in writing or through electronic means. Okay, so the RTI Act provides for filing it through electronic means. You can do it through email, provided that that government department has a system enabling such kind of a correspondence. Okay, now just in reference to this, let me show you something interesting. Is a recent activity in the current affairs. Take a look at this. This is a recent update. This is very current affairs, not to kind of supplement your question with the point that is present in the current affairs. Okay, take a look at this part. As a headline, what does it say? Supreme Court gives states, UTs and high courts 3 months to set up online RTI portals. So what it is doing is that the court enforcing section 6 of the RTI Act is giving directions to the high courts, union territories and states 3 months to set up online platforms on which an RTI under an email can be registered. It is correct that we do not today have all the departments in the government of India or the government of states which are accessible on email with regard to RTI. But the Supreme Court is already taking care of that. Invoking section 6 of the RTI Act, where it is written electronic means, it is telling them by directions that you have to set up your online portals for the filing of the RTI. It is not a choice. It is a necessity. You have to comply with it. Okay. This is March 25, 2023. It can be a part of a current affair. Okay. Take a look at this. The Supreme Court has directed states and union territories to set up and operationalize online right to information portals within 3 months to ensure transparency in governance. The court gave the same 3 months time to register generals of state high court to establish and run an online RTI portals in the respective high courts and district courts. Okay. RTI portal to help people access information about Supreme Court operationalized. Supreme Court already has got online. If you want to get an information from the Supreme Court, you can actually email it. You get the point? So that's one answer to your question. Mr. The petitioner had argued that section 1 of the RTI stipulated that information seeker had a statutory right to move an application through electronic means. This is what I was telling you, right? So based upon this interpretation, the Supreme Court has said that an RTI can be made through an email also. So March 23, Supreme Court has given all the states in India from March 23 3 months to set up an RTI online portal. If a government department in your area is not setting up an online portal or is saying कि email में नहीं होगा etc., at least tell them कि March में 3 महीने का मोहलत दी गई थी. If you don't do it, it is going to be a contempt of the court under Article 129 for the Supreme Court. You actually can go and file a petition before the Supreme Court saying that despite your pressing of the matter, these departments have not yet comfortably allowed the RTI to come in. Okay. Does that answer your question about the email? Nimai, and there was another question on email. Nayan, right? Makes sense? Give me a yes or no. Come on, guys. I need some response. Otherwise, a man without an audience cannot speak for very long. Make me feel that you're hearing me on the other side. Okay. This is one question. Then there is a question by Spandan. Some traffic police constables, civic volunteers wearing police uniforms demands high amount of fine showing our faults and tell us that you have violated this, so you have to give 30,000-40,000 rupees. My God. But all the things are settled if we pay the constable. This is corrupt practice. Now, if we're right, we have all the documents and never violated any rule in this case. If they fine 30K, can we made RTI file? What happening those things? हमारे पास तो कोई evidence भी नहीं होती है. हाँ, exactly. तो वही तो ना. If you find, see, I'm not completely sure of what the facts of the matter is that you're stating, but you feel that RTI is an evidence. You have to find a way by which an evidence can be collected and given to your hand. Okay. So for example, let's say I'll give you an example of how you can deal with a situation like this. Let's say police stops you, traffic police stops you, and let's say fines for 10,000 rupees. Okay. And then let's say it gives you a receipt कि आपको रसीद काट के दे दी. But you know that this receipt is fake. You know that this is just a kind of a, it is not a government thing altogether. You keep that receipt with you, and now you go to that department and file an RTI to get your receipt. You get a copy of your receipt. Okay. So let's say, for example, you will find surprisingly that if the people have taken 10,000 rupees from you and given you a receipt, the real government receipt would have maybe the fine of 2,000 rupees. Okay. And the rest of the 8,000 rupees has been taken by the police or the department. So by getting this kind of a asymmetry in evidence, you obviously can say कि मेरे पास 10,000 की receipt इन्होंने दी है. They've given me a फर्जी receipt, right? And what they have given the government as a fine and a penalty is only 2,000 rupees, which means 8,000 rupees they have eaten up in the middle. So that's one of the ways in which you can deal with it. So even if you're paying fine or something like that, they generally give you something in writing. कुछ ना कुछ कर देते हैं. Not this is small ticket transaction 2-3 रुपए, पर लेकिन अगर बड़ा फाइन लगाते हैं आपको तो वो उसकी भी रसीद देते हैं. But that receipt is just a kind of a manufactured thing. It doesn't have any evidence. उनको लगता है कि कोई क्या करेगा, जो होगा सो देख लेंगे, बाद में भी तो पैसे आ रहे हैं ना. That kind of thing happens. Okay. Okay, so Shubhrata, I'll take your question about the RPA a little later because abhi maine thoda sa I moved on with it, but I'll look at this question later on. Hmm. Is there a protection for the person who's applying for an RTI? Suppose if any IPS officer involved in any type of corruption and he's also PIO, then if let's, of course, we are coming to that. What we'll see is कि मान लो कि if a PIO has refused an information to you, उसने मना कर दिया, I'll not give you information, क्या करेगा? मना ही तो कर देगा if he's corrupt. Then you can go to the central information officer, CIC, and CIC will have the powers over the PIO to force him to reveal the information. So there is a very good appellate structure which has been created, which I'll deal with later on. But if the PIO rejects your application, it is not the end of the line. You have ways to which you can go to higher authorities and start working on the activity of doing this kind of a thing properly. Okay, got my point? So appeal ke hai methods. We'll take a look at the Chief Information Commissions, the Chief Information Commissioner and the Central Information Commission as superintending bodies over the public information officers everywhere in the country, and they have a right to prosecute them, even suspend and expel them if they're not giving the information. Okay. Please tell some point like sentence so that we can write 1-2 lines in each point. Stick. So that's a good idea. For all of these, let me give you a few notes. On section 3, 4, 5, 6, 7, 8, I'll give you 2 lines each to get you a sense of this that you can write. Okay, with regard to email, I already answered. Can RTI even be filed after some times of corruption happened, suppose 1 month or 2 month more? Yes, yes. There is no time limitation to an RTI. If the government has that information, you can get the information at any given point of time. There's no time limit to it. You can get information even about something that happened in the 1970s. No time limitation with regard to RTI. If DM is head of that public authority, then we have file RTI to that DM? Yes. Generally, the concept is that the person who's heading the organization has all the information with himself, and only he can give the information out because only he has the information control over things. So he is the one who's supposed to be the PIO. Again, this question of state election commissioner, I'll have to return back to this because this has been taken out. Abhi, we'll come back to it. A PIL to bring the political parties under RTI has been filed in Supreme Court very recently. Supreme Court on agreed to hear it in 1st August, bringing political parties under. Will it enhance transparency in our political system? Anil, again, a very good observation. You seem to be an adept reader of the current affairs. You say things before I would mention them in my own course. But just please wait. Let me come to the point of political parties and RTI, and we'll discuss that properly. Okay. Keeping in mind that political parties do not fall under the definition of public authority. I tell you, Supreme Court will not allow this because political parties are not governments. They are individual private entities, and they can be called to be performing public functions, but to be covered under RTI requires a little more elementary nature of public function than politics. So Supreme Court will reject it. But nonetheless, your question is poignant in terms of reflecting at the dismal state of affairs of the complete lack of transparency as the kind of money the political parties have today. Okay. Can we file our RTO to know information about India's international affairs? Vidisha, well, you can. It depends upon the government whether it wants to release it or not. Right? Government can, as you have, for example, seen under Section 8, if the government wants, it can tag it as an exemption. Okay, so that would depend upon the government of the ministry if it wants to do it or not do it. Right? If it's a simple question which doesn't have too much controversy around it, the government may give it to you. But let's say, for example, if you ask the question, where are Indian army posted in the Doklam region or in the Pangong So Lake region, they will not give you that information, stating that this information, which will prejudicially affect the sovereignty and integrity of India, security, strategic, scientific, or economic interest of the state. Okay, this kind of a thing. can happen over here. So that depends upon the discretion of the government, which can be challenged. The final authority remains with the CIC, Chief Information Commissioner of India. He will decide whether the government's refusal to give any information is covered under Section 8 or not covered under Section 8. Okay. So even the government's refusal to give information on these matters can be challenged. The decision has to be taken by either the court, Supreme Court or High Court, or by the Chief Information Commissioner. Okay, which are both considered independent bodies. By that I mean independent from the government. Okay. Okay. So let's just execute that point that you mentioned about giving you 2 lines each of them. Okay. So what you can do is you can just give very simply a title called the RTI Act, right? And then in this title, write the first point A, section 3 to section 8. Okay. We'll write this down very simply, section 3 to section 8. And first point under this, write down section 3. Okay, just a little bit of a write up upon what we have discussed so far with regard to the RTI. Please write down, class. Section 3. Section 3 guarantees the right to information. Section 3 guarantees the right to information. Section 3 guarantees the right to information as a statutory right to all citizens. Guarantees right to information as a statutory right to all citizens. Section 3 guarantees right to information as a statutory right to all citizens. Okay, am I clear? I'll say it again. Section 3 guarantees right to information as a statutory right to all citizens. Okay. Now write down section number 4. Very briefly, I'll just paraphrase it for you to remember the important parts about it. Section 4. Let's write the section 4 down. Section 4, write down. It creates an obligation on every public authority in India. Section 4 creates an obligation on every public authority in India. Section 4 creates an obligation on every public authority in India. On every public authority in India to catalog and index information so that it becomes easy and accessible. So that it becomes easy and accessible. So that it becomes easy and accessible under the RTI Act. Under the RTI Act, comma. Under the RTI Act, comma. It also prescribes that information must be digitally stored. It also prescribes that information must be digitally stored. Information must be digitally stored. And transmitted through a network to all the central and nodal authorities concerning that department, to all the central and nodal authorities, to all the central and nodal authorities concerning that department, all the central and nodal authorities concerning that department. All the central and nodal authorities concerning that department. Full stop. Okay, this is section 4. Are we clear? Very simple, precise paraphrasing of these things. Section 5, write down. Section 5, write down. It prescribes the establishment of the public information officer / PIO, the establishment of the public information officer brackets में PIO, public information officer brackets PIO, public information officer brackets PIO who has the responsibility of receiving RTI applications, and responding to them, who has the responsibility of receiving RTI applications and responding to them, comma. The PIO is generally, comma, the PIO is generally the head of the concerned department, full stop. For central government departments, there is the CPIO, for central government departments there is a CPIO, and for state there is the SPIO, and for the state there is the SPIO. Full stop. An assistant public information officer, an assistant PIO brackets में APIO, an assistant PIO can also be instituted if required. At both central and state levels. Full stop. Are we clear? At both central and state levels. Clear? ठीक है? This is something you understand now properly? Okay. Then we take a look at section number 6. Write down the procedure to file an RTI application. With section 6, just write down a kind of a subtitle over here. The procedure to file an RTI application. the procedure to file an RTI application. Okay. Right. Under this, you can say any person, any person, any person can request information from a public authority, from a public authority, can request information from a public authority. Any person can request information from a public authority without 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 any reason, without any reason, and even without revealing personal details, without any reason and even without revealing personal details. Without any reason and even without revealing personal details. Without any reason and even without revealing personal details. Brackets में only enough to receive a response to the application. Brackets में only enough to receive the response to the application. Only enough to receive the response to the application. Only enough to receive the response to the application. Brackets closed. Can file an application, brackets closed, can file an application to the PIO of the concerned department. To the PIO of the concerned department. To the PIO of the concerned department. Full stop. If the person is not able to write the application, if the person is not able to write the application, if the person is not able to write the application, if the person is not able to write the application, he shall be assisted by the PIO. He shall be assisted by the PIO in writing it. He shall be assisted by the PIO in writing it. This is section 6. Full stop. A prescribed fee, just write down another sentence about this, full stop. A prescribed fee through a stamp has to be paid for each application. A prescribed fee through a stamp has to be paid for each application. A prescribed fee through a stamp has to be paid for each application. A prescribed fee through a stamp has to be paid for each application. Generally, this fee is 10 rupees. In all over India, RTI can be filed with, on the letter of RTI, you just have to pay a stamp duty of 10 rupees. You have a postal stamp that you can paste on that for 10 rupees. See here, this is an example of a RTI application. A 10 rupee stamp is attached Take a look at this. To the Public Information Officer, Food and Supplies Department, M Block, Manjurnagar, Ahmedabad. Request for information under RTI. Sir, ma'am, please provide true certified copies of the following: daily progress made on my ration card application from January 25, 2014 till date. Names and designations of officials taking action on my application. Name Seema Verma, address this, mobile number not given. I hereby inform that I am a citizen of India. I am above poverty line. A copy of my passport is attached. Okay. So this is an example of a person who wants to attain the BPL card. Okay. And the person has applied for such application, but the decision has not been made by the department concerned, Food and Supplies Department. So this is the information that one is asking: what is the progress made on my ration card application, and names and designation of officials taking action on my application. Right? This is what you can call a very simple way of writing an RTI. That's all that you need, and you need a 10 rupee stamp which is going to be paid for it as a fees of the RTI. Right? I hope you get a clarity by looking at this particular thing. It's very easy. It's really very easy. Okay? ठीक है. Now we take a look at the other matter after this, which is section 7. Write down. Response time. Section 7, response time. Write down. Section 7, response time. Write down. Upon the receipt of the application, the PIO, upon the receipt of the application, the PIO, upon the receipt of the application, the PIO, receipt of the application, the PIO has to respond to the application either by providing the information, either by providing the information, either by providing the information, or either by providing the information or by rejecting the application, rejecting the application under section 8 and 9. 8 we have already covered, which is exemptions, right? Under section 8 and 9. Okay? Semicolon after this, write down, semicolon. Such response in yes or no must be given. Such response within yes or no must be given within a 30-day period. Within a 30-day period of receipt of the application. Within a 30-day period of the receipt of the application. Within a 30-day period of the receipt of the application. Must be given within a 30-day period of receipt of the application. Okay? Make sense? Day period of the receipt of the application. Okay. In case of information impacting life and liberty, in case of information impacting life and liberty, response must be made within 48 hours. In case of a case of life and liberty, impacting life and liberty, response must be made within 48 hours. Response must be made within 48 hours. "48 hours, full stop." Keep writing after this full stop. If the application is rejected, the PIO must communicate. If the application is rejected, the PIO must communicate. If the application is rejected, the PIO must communicate the reasons, comma, the process and authority for appeal. The process, the reasons, comma, the process and authority of appeal. The reasons, comma, process and authority for appeal. Reasons, comma, process and authority for appeal. Right? Okay, this is section 7. And then we come to section 8. Section 8. Okay, write down section 8. Exemptions from RTI. Or just write down, don't write exemptions. Write down section 8. Categories of information. Categories of information exempt from RTI. Categories of information exempt from RTI. Categories of information exempt from RTI. Exempt from RTI. Okay, write down. Section 8 lists. Section 8 lists kinds of information. Section 8 lists kinds of information such as security related, comma, foreign relations related, comma, intellectual property related, intellectual property related, intellectual property related from being released under the RTI. From being released under the RTI. From being released under the RTI. Full stop. The PIO from being released under the RTI. Full stop. The PIO can reject the application. The PIO can reject the application. The PIO can reject the application on the basis of these exemptions. On the basis of these exemptions. Okay, ठीक है? So section Uh, Sorry, there was a uh, network glitch. Some reason network didn't come for 2 minutes. Please confirm if the audio video is back, all of you. Please let me know if the audio video is streaming properly now. Guys, we are here. Can you hear me? Okay, cool. Right. So we are taking a look at section 8 and section 24 more or less in correspondence to each other. Okay. Section 8 tells you the items which are going to be exempted from the RTI. Okay. Items which are exempted from the RTI. That's what section 8 talks about. Right. Section 10, sorry, section 24 on the other hand talks about organizations which are exempted from the RTI. Right, all the organizations which are mentioned with reference to section 24 are exempted from RTI. In organizations में public information officer होता ही नहीं है. By the nature of these organizations, for example, the Border Security Force, CISF, CRPF, all these organizations which are, let's say, for example, involved in ensuring the security and territorial integrity of India, they are not covered under the ambit of the RTI Act. So section 8 says that in any organization, informations which are kept, which are falling under section 8 will not cover under RTI. What it means to say is that if there's a information with regard to, let's say, with regard to foreign policy, which is with the Ministry of External Affairs, which is not to be released because it may impede a relationship of India with another country. Okay, so that will not be released, but other information from Ministry of External Affairs can be released. Section 24 talks about the entire departments and organizations which cannot be converted into RTI. Okay, take a look at this article 20, section 24. Nothing contained this act shall apply to the intelligence and security organizations specified in the second schedule, being organizations established by the central government or any information furnished by such organizations to that government. Right, provided that the information pertaining to the allegations of corruption and human rights violations shall not be excluded under this subsection. Okay, provided further that in case of information sought for is in respect of allegations of violation of human rights, the information shall only be provided after the approval of the Central Information Commission, and notwithstanding anything contained in section 7, such information shall be provided within 45 days from the date of the receipt of the request. Okay, so just very simply take a look at this particular part first. Section 24 subsection 1 gives you a set of organizations on which ordinarily RTI will not apply. RTI will apply to them only in two instances, that is on the allegations of corruption or human rights violation. Okay, and with regard to the allegations of human rights violation, the decision cannot be taken by a public information officer. It has to be taken by the Central Information Commission, CIC. Okay, so first of all, let me just direct you to the second schedule, which mentions these organizations. Okay, second schedule. Take a look at this. These are the organizations given under the second schedule in reference to section 24. Take a look at these organizations and try to find a common theme within these organizations. Intelligence Bureau, right? Research and Analysis Wing, which is RAW, including its technical wing, namely the Aviation Research Center of the Cabinet Secretariat. Directorate of Revenue Intelligence, Central Economic Intelligence Bureau, Directorate of Enforcement, Narcotics Control Bureau, Special Force for the Cabinet Secretariat, Border Security Force, Central Reserved Police Force, the CRPF, Indo-Tibetan Border Police, ITBP, Central Industrial Security Forces, CISF, National Security Guards, Assam Rifles, Sahastra Seema Bal, Directorate General of Income Tax, National Technical Research Organization, Financial Intelligence Unit India, Special Protection Group, SPG, Defense Research and Development Organization, DRDO, Border Road Development Board, BRD. These are organizations which have a kind of a similar theme and character, which is the fact that they are involved in some way or the other, ensuring the security and territorial integrity of India. You get the point? So the actions which have to be taken with regard to RTI on these organizations cannot ordinarily be possible. They are only possible in the event of a corrupt practice, right? For example, if there is a person within the CISF who has been alleged for doing some kind of a corruption, then you can file an RTI with the CISF, or you can file an RTI with the CISF on the basis of human rights. Just that specifically for human rights, the RTI has to be filed with the Chief Information Commissioner. It is the CIC who will take the decision whether the information pertaining to human rights violation shall be released or not, right? So it is in the hands of the Chief Information Commissioner, not the Public Information Officer. Okay? Right? So this is section 24 for us. Alright, section 8 and section 24, both of them cover exemptions. Section 8 covers categories of information which are exempted from all organizations. Section 24 covers all organizations which are exempted from RTI, except on the allegations of corruption and human rights violation. And that too, for human rights violation, it has to be ascertained by the Chief Information Commissioner, the Central Information Commissioner, not a PIO. Right? This is a special status which has been given to these organizations, and we've taken a look at these organizations which are present in the second schedule of the RTI 2005. Hope that helps understand this better. Okay. So just under section 8, breaking the pattern, please also mention section 24, because both section 8 and section 24 have the same theme, that they are covered under the exemptions part. Okay. Write down section 24 quickly. Section 24, please. Section 24. It provides that organizations created by the central government, it provides that organizations created by the central government, or reporting to it, and mentioned in the second schedule, of the RTI Act, cannot ordinarily be subjected to RTI. Cannot ordinarily be subjected to RTI. Just underline the term ordinarily. Cannot ordinarily be subjected to RTI. comma, but only on two grounds. Only on two grounds. That is corruption, but only on two grounds. That is corruption. Sorry, that is corruption की जगह आप लिख दीजिए. That is allegations of corruption. Allegations of corruption and human rights violation. Allegations of corruptions and human rights violation. Allegations of corruption and human rights violation. Allegations of corruption and human rights violation. But only on two grounds. That is allegation of corruption and human rights violation. Clear? Full stop. WRT with regard to human rights violation. With regard to human rights violation. With regard to human rights violation. RTI can be made only with the permission of the Central Information Commission. RTI can be made only with the permission of the Central Information Commission. RTI can be made only with the permission of Central Information Commission, CIC. Only with the permission of Central Information Commission, CIC. Full stop. Okay? And keep writing this. Some examples of these organizations are. Okay, we can take some examples from it. For example, Directorate, comma, Border Security Force, BSF, Border Security Force, BSF, comma, CRPF, comma, ITBP, comma, CISF, comma, NSG, comma, SPG, etc. Take, you know that they have the same theme of securing the security, protecting the security and territorial integrity of India. Right? Okay. Brunal has a good question with regard to the third party information. We are going to cover that part only. The next thing that we would cover is going to be the third party information only. It's interesting bit to understand that specifically. Section 11 will consider third party information. So we'll take a look at that once we arrive there. Okay. Nimai. Is there any similarity between items that are exempted from RTI and seal jurisprudence when a case needs information from the items exempted from RTI? Well, yes, the similarity is the security, sovereignty, territorial integrity of India, right? Anything which is, of a nature which hurts the sovereignty, integrity and security of India, that kind of a thing itself becomes a similar quotient between all of these things in which information becomes confidential. For example, you have the Official Secrets Act, which has the same theme again with regard to security, sovereignty of the nation, and everything which is associated with national security. That kind of a thing is exempted mostly from these points. A few years ago, an army put an application that they are not providing good nutrition. Is it come under RTI? Well, I don't remember about an application being put with this regard, but there was some video which was released by a infantryman. He was showing how the nature of dal and rice they got was so inferior in quality that it was not even good for fighting a simple, whether the nutrition that they were getting was very bad. I'm not sure about the RTI. Maybe if you can give me the reference point to that, I'll be able to answer that specifically. If you have a news article or something, you can forward me a link to. I can take a look at that, but I'm not able to recollect where it is. I'm not able to see when an application was made by the army people itself about nutrition. Okay, right. So we have done with section 3 to section 24. Okay, let's move on. Tick. So we're moving towards section 9. Let's see if we have to cover section 9. We can say the severability. Yeah, we can take section 10 into account a little bit. We can skip section 9 and come to section 10. So 8, 24 and 10. 10 talks about severability. It's very simple really. There is something called a doctrine of severability which is generally covered under the course of polity. Okay. In the doctrine of severability, the point that is made is that, for example, you have Article 13 of the Constitution. Right? There is an Article 13 of the Constitution which states that if a law is in abrogation or is inconsistent, if there is a law which is in abrogation or inconsistent with fundamental rights, that law should be declared to be invalid. But what it says is that the invalidity should be declared only to the insofar as it is in abrogation or inconsistent. Okay, so for example, if a law has been made and these sections of that law abrogate or are inconsistent with the fundamental right, then what it says is that the judiciary should surgically remove out this section. Okay, the judiciary should sever out this section. Okay, sever meaning to cut it out, as if you are removing a tumor from a healthy organism otherwise. Right, and this is what is an example of doctrine of severability. Okay, and what you see, for example, in the article 10 of this is that, let's say, for example, what it says is that, let's say this is an RTI application which has been made. This is the RTI application which has been made to a officer, to a PIO. Okay, now what it means to say is that if, for example, this part of the application, this section of the application is falling under an exemption under section 8, let's say, for example, it is giving out certain intellectual property rights. So what section 10 says is that this part can be rejected from giving, but the remaining part should be given out as information. That is what section 10 of the RTI Act talks about. It is a application of doctrine of severability. Similar to Article 13, when Article 13 states that a particular activity, a particular law, if it is inconsistent or in abrogation with a fundamental right, insofar as it is inconsistent or in abrogation, it shall be declared to be void. Similarly, the actions taken by the RTI, the PIOs, should only move out these actions which are inconsistent with the section 8, but otherwise it should be able to give the information. Okay, take a look at it. Section 10, just a very simple understanding of this. Please read section 10. Where a request for access to information is rejected on the ground that it is in relation to information which is exempt from disclosure, then notwithstanding anything contained in this act, access may be provided to that part of the record which does not contain any information which is exempt from disclosure under this act and which can reasonably be severed from any part that contains exempt information, right? This is what is known as severance, severed, meaning cut out, surgically removing something. Okay? No, Biswajit, the video is not an RTI application. Okay, video is just a kind of a, maybe that was an example of whistleblowing, not an RTI application. There was no formal, you have to go through the framework of laws and procedures to file an application about something. There is no formal application which was filed about all of this. So this is what we are taking a look at in terms of only being an informal kind of a mechanism. Okay, ठीक है? Just write down a little bit about section 10, please, and we can move forward then. Write down a little bit about section 10. Section 10, write down. Section 10. It mentions the concept, it mentions the doctrine of severability. It mentions the doctrine of severability. It mentions the doctrine of severability where it mentions the doctrine of severability where it identifies the part within an RTI application, where it identifies the part within an RTI application, where it identifies the part within an RTI application which is exempted under section 8, which is exempted under section 8 or 9, which is exempted under section 8 or 9, which is exempted under section 8 or 9, and rejects information on that part, rejects information on that part, rejects information on that part, but does not reject information on the remaining part, but does not reject information on the remaining part by the application of reasonable severance, by the application of reasonable severance, by the application of reasonable severance, by the application of reasonable severance. Okay? By the application of reasonable severance. All right. Okay, this is section 10. Now we move to the question that was asked about third party information. The question which basically is this, that let's say I'll demonstrate a scenario for you. What is the question about the third party information? Let's imagine, for example, if there is a department which is under the government of India, central government of India, which has a CPIO, right? Let's say if this person is filing an RTI to the CPIO over here, in which, let's say, for example, it is asking information about Mr. X, who is, let's say, for example, an officer in this department. Okay, please pay attention to what I'm saying. You have this person who's filing an RTI with this department, asking information about Mr. X, who's an officer in this department, right? Let's say, for example, he's asking for his degree qualification. Okay, he's asking for his degree qualification. When the degree is going to be given in the public domain, the name and location of his native city is also going to be revealed. Okay, you see the point? Let's say, for example, there's some kind of a mafia angle to all of this, that let's say I am an honest public officer and I am doing some job properly, and to threaten me, some mafias, what they are doing is they're trying to find out where does my extended family live. They're trying to trace my village. Okay, so one of the ways they want to do it is they want to get access to my degrees on which you have the, or my school certificate, and they'll know where I did my 10th and 12th from, so that they can identify where my village is and they can go there and locate my family and try to threaten them. Okay, they want to play this kind of a blackmailing game. Now, this kind of a question, if it arises, that when a person is asking from an RTI some kind of a information of a person which is a little personal in nature, okay, it is not with regard to only the activities of this person with regard to his abilities to perform in the office, but also it is information which is in some kind of a personal capacity, of information which is in a personal characteristic. Okay, so this information is what is qualified as a third party information. And now this is the point about it. If the PIO, what over here he has to do under section 11 is that before revealing this information to the RTI, he will notify Mr. X that they are asking for your high school mark sheets. And if you have any objections, you please raise them now. Okay, so let's say if I am a person against whose an RTI has been filed asking for my high school mark sheet, the PIO will consider this a personal information, a third party information, and third party information, for example, this can be an information about my relatives living in the village who are third party to this entire thing, right? So the PIO will ask me the notify me first of all that this kind of a information is being asked of you, asked about you by a RTI, and if you want to raise an objection to it, you can raise an objection to it. Now if I raise an objection to it, the PIO can say that this is a third party information and we are not going to give it under section 11. Okay, but the PIO can also say that in the larger interest of the public, this information must be given, even if it is compromising a person's privacy or personal liberty. But in the larger interest of the public, this information can be given. So this kind of a discretion lies with the public information officer, in which he decides whether this information forms the part of the what you call the third party information, or if it forms a part of third party information, it depends upon the the balance between personal liberty and national interest. So if the national interest is higher, let's say for example by revealing some information, it leads to a lot of larger public good, then the information will be released. But if with the release of information it does not lead to a larger public good, then the third party information can be rejected under the RTI. That is what is given under section 11 of this particular act. Okay. Please take a look at this section 11. Take a look at third party information section 11. Please just read this. Read this. Okay, this is the answer to what is a third party thing. So whenever there is information with of any nature which is not pertinent to the case but is about something personal, which can lead to deduction about third parties or directly about third parties, then the PIO first has to notify the third party or the person who's holding the third party information and ask them to raise an objection and then decide upon this. Now, but this is a principle that in trade of commercial secrets protected by law, disclosure may be allowed if the public interest in disclosure outweighs in importance any possible harm or injury to interest of such third party. Okay, so in let's say for example, if the third party information includes trade or commercial secrets, right, then the public interest will be paramount to the personal activities. You get the point? So this is a little bit about the third party information. right? The all thing said and done, it means that the third party shall be allowed to make representation objecting to the information being released about that particular person in the RTI at section 11. With the completion of section 11, we have completed the second chapter of the RTI. This is about 60% of the RTI Act completely done. Okay. What is remaining after this is the whole idea of what is known as the Central Information Commission. That's what we have to take a look at. Central Information Commission, we are going to now move in the direction of covering what is called statutory bodies. Okay, what we are covering is called statutory bodies, and within statutory bodies, one of the first one we are covering is CIC. But CIC, not only being a part of the statutory body, is also a part of RTI. So we are covering it in both these senses. Central Information Commission is the next part that we're going to deal with, and we'll understand. For example, let me give you a brief overview of it. If, for example, you have, this is the Republic of India, and these are government departments within the Republic of India, right? And within each of these government departments, there is a PIO, Public Information Officer, state or center. And the PIO is supposed to be the one who is supposed to give information to the citizens of the country. Let's say, for example, these are citizens of the country. Okay, and they are interacting with the PIOs to give them information. Right. Now, this is what our ecosystem looks like with regard to the RTI 19, RTI 2005. Now, the point is that if, for example, if these people stop giving information, or they reject information, or they say that information is not available, or they give incomplete information, what is the solution to that? And to solve that, you have created a Central Information Commission.